Good morning to everyone watching. My name is Val McIntosh, and I'm a debate coach here at the University of Michigan. And I am very excited that we are joined this morning by Eve Primus, who is the Yale Chemisar Collegiate Professor of Law at the University of Michigan. She specializes in criminal law and criminal procedure, and her teaching and scholarship focuses on structural reforms to the criminal justice system. So we are very excited to have her speaking with us this morning. If you have questions, you can feel free to add them to the Google form on Canvas or to the Q&A on Teams, on Zoom. And when she's finished, we'll go through and I'll read out some of those questions, and Professor Primus will answer them for you all live. So with that, I will turn it over and you can get started.
Okay, great. Well, thank you so much for having me here. It's a pleasure to be here and to interact with you, albeit virtually, for your debate program. I want to talk to you a little bit about what criminal courtrooms are really like, because it's hard to talk about reform until you know what it is that you're trying to reform. So typically, when people think of a criminal courtroom, they tend to think of something that looks like this, right? They see a trial with a jury there to decide the facts, a judge at the front of the room to issue the legal rulings, and two lawyers, one on each side, each prepared to fight zealously to help the jury reach a fair verdict. The unfortunate thing is that almost everything about this vision, which is the typical vision people have, is wrong. So the first thing you need to know is that in a lot of criminal cases, there actually are no defense lawyers to represent the person who is accused of crime. Misdemeanors are about 80% of a state criminal court's docket. It's over 10 million cases a year that are misdemeanor, or what we would call relatively more minor offenses. These are offenses that are processed quickly through the system. They often have one court date, only a few minutes devoted to each case. And many of these defendants will go on trial or have a plea situation without a lawyer present. So here's just one example of a jurisdiction. This is Yolo County, California from 2017. Their misdemeanor defense counsel percentages. They are a state that had a public defender in about 28% of the cases that involved misdemeanors, and private or other lawyers in another 7 to 8%, but 73.5% of the cases involved no lawyers whatsoever for the defendant. And if you've studied a little bit the criminal justice system, you may wonder how that's possible, because there's a very famous Supreme Court case from 1963 called Gideon versus Wainwright that says, in our adversarial system of criminal justice, any person who's brought into court who's too poor to hire a lawyer can't have a fair trial unless the state provides a lawyer for that individual. So you would think that if there was someone who was charged with a crime and they couldn't afford a lawyer, that a lawyer would be appointed for them. But the United States Supreme Court has said only if you are facing actual imprisonment afterwards will you get a lawyer in our system if you can't afford one. And since over 80% of the defendants who are charged in our criminal system are poor individuals who can't afford a lawyer, and many of them are not ultimately actually incarcerated afterwards, many of them don't have lawyers. And even when they are actually incarcerated afterwards, many of them don't have lawyers. There are a number of organizations, from the American Bar Association to private and other public interest groups, that go around the country investigating the indigent defense delivery systems that we have in this country. And here's an example of a report from one of them, from my home state here in Michigan. This was a report in 2009 where they gave a report card to the state of Michigan after a 2008 investigation into the way criminal justice was performed in this state. And they realized that in many jurisdictions, in many counties around the state of Michigan, no lawyers were being provided whatsoever, and people were being sent to jail after a plea or after a trial. It was so bad in one county that they actually referred to the practice of going to court as McJustice Day in this 2018 report. Part of what this tells you is that the law, in theory, and in constitutional protection is often quite different from the law in practice. How is it possible, my law students will often ask me, if there's a constitutional right to have a lawyer and people are being sent to jail or to prison, how is it possible that they're not being given that lawyer and that no one is doing anything about it? And part of the answer is that these are very low visibility courtrooms. Misdemeanor courtrooms are not places that get a lot of appellate review. Why? Because the sentences that are given after you are convicted of a misdemeanor, even if they involve jail time, they tend to involve less jail time than the more serious felony offenses. And so what that means is, for many defendants who are sentenced to jail after being convicted of a misdemeanor, the time that it would take to appeal that decision and have an appellate court review and say, no, you were denied your constitutional right to a lawyer, would exceed the amount of time that these individuals would be incarcerated. So there's no incentive for them to do this. And so these misdemeanor courts often go relatively unchecked. So there are many studies from different states documenting the problems with indigent defense delivery systems. And it's not just that you have situations where people are denied their rights to a lawyer altogether. You also have around this country many, many studies documenting the fact that there is not enough funding and support given when there is a defense lawyer system in place to actually enable those defense lawyers to provide zealous and constitutionally adequate representation. So the defense lawyers around this country are underfunded and overworked in incredible ways. So here's just an example. This is public defender is a name that I will give for state-funded defense attorneys that are provided to individuals who are poor. So back in the 1970s, the American Bar Association did a study, and they determined that, look, no lawyer in this country should have to handle more than 400 misdemeanor cases in a year or 150 felony cases in a year, right? That was the maximum that you could do effectively. And the Sixth Amendment to the Constitution says that everybody has the right to effective assistance of counsel. So if you want, and this was, mind you, this is the 1970s. This is before DNA is invented. This is before a lot of forensic science comes into being. This is before email and all of the documents that can be created that would be discoverable and would complicate investigations. So if anything, these numbers sort of are higher than they should be in terms of what a person could effectively handle if they were representing people. But if you go around the country and you look at what the actual caseloads are, here's what you're going to see. You're going to see in Miami jurisdictions where they're handling more than 700 felonies in a year. You're going to see Chicago and Atlanta with more than 2,000 misdemeanor cases per lawyer in a year. There's one study from New Orleans that they handled more than 19,000 misdemeanors in a year. I just want you to let that sink in for a minute and think about what kind of representation a lawyer can provide when he or she has 19,000 cases in a year. They broke this down, the American Civil Liberties Union, into the estimated time each attorney has to spend on a case in New Orleans, and it was 7 minutes. 32 minutes in Detroit, 59 minutes in Atlanta. That's for the entire case. That's the amount of time the lawyer has to meet his or her client, do any legal research, do any investigation, think about what defenses to mount, negotiate with the prosecutor, potentially take a case to trial. As you can see where I'm headed, there are not going to be many trials here, right? This is a massive problem when you think about the indigent defense delivery systems in our country. We are creating a situation where defense lawyers are just structurally ineffective. Like, they cannot provide the amount of representation that would be required to actually serve as adversaries and test to get to the truth in our criminal justice system. In many jurisdictions, they have no investigators to help with the defense function. And they often will have systems that are so underfunded that lawyers who come in to represent criminal defendants will get little to no training, and they don't get much oversight. So I'll tell you, I was a public defender before I was a law professor, and my typical day in a criminal courtroom would exist of my having to go in between 3 different courtrooms when I had a misdemeanor docket. And I'd have, on a given day, between 20 and 30 files in an accordion folder under my arm. And it would start, the doors to the courtroom would open at 8:30. And I would be running between and among these courtrooms, talking to the prosecutors. That was the moment when they would provide me with whatever information they had about the case, which what we call in the law discovery. They would give me everything, however thick it was, this thick to this thick, and I would have it right then and there. I had to go photocopy it myself because they didn't provide me copies. So I would run to the photocopy machine, copy the discovery while I'm trying to read it for over 20 cases in a day, hand it back to the prosecutor. Meanwhile, all the witnesses would be checking in with the prosecutor. I would have to find my clients, or if they were locked up, go up to the lockup to talk to them, find out who was there for the prosecution side, find those individuals and talk to them, and decide with my client whether there was going to be a plea or a trial on that very day. Judges would call me in various courtrooms. I mean, it's insane to think that this is how we determine whether someone should remain free or be locked into a cage. And that is how we do it. It gets a little bit better when you get to felonies, but it depends on where you are. If you're in Miami and you have more than 700 felony cases in a year, you still don't have the time that you need in order to adequately represent people. And I was a public defender in Maryland, which has a good statewide public defense system, which means it's organized centrally, and there's central training and oversight and administration, and each county has subdivision offices, and there are standards and everything like that. Only 22 states have statewide public defender offices like that. Right? And even those states have massive caseload and funding problems in the way that I've just described. When I was a public defender in Maryland, Baltimore was still handling over 1,000 cases a year. So even in a good system where I had training and support, there still was a massive influx and overload in terms of the cases. And there are not all states, as I said, have public defender offices at the level. The other ways you can provide lawyers in our system are to have what is called an assigned counsel system. So what does that mean, right? That means that you have lawyers who are conscripted sometimes into providing for indigent defense, or they just sign up to be on a roster. And as defendants come into the courthouse who are poor, who need representation, the judge or some administrator taps individuals to take on these cases. They are paid an hourly rate typically if they work for an assigned counsel system, or sometimes what we call a per event rate, which means that they're paid by the plea or by the trial or by the case. But for the most part, the dominant mode is to pay them hourly. But here's the problem. No funding, right? So they can be paid as low as $40 an hour. And there often are caps, which means if they get an indigent defense case, they're often told you can only bill up to X amount on this case. And those can be as low as $500 per case. So think about what incentives that creates. If you're a lawyer who gets a case where you're being paid $40 or $50 an hour and your cap is $500, you can spend, if it's $50, 10 hours on that case. And after that, everything you do is uncompensated labor. Your incentive is to dispose of that case relatively quickly, because if you get another, then you can start over and work your way up to your cap. So the incentives here are to plead to get to the next case. And oftentimes, because the caps are so low, the lawyers can't make a living wage off of being an assigned counsel lawyer, so they have to take on private cases, and the public defense cases tend to be like a side job in a lot of jurisdictions, which only increases the limited amount of time that they've got. So they have a similar time crunch when they're addressing these cases. The last way indigent defense is often done is through what we call contract systems. So this is often a situation where a group of lawyers will come together and they'll bid on the indigent defense contract for a given place. And what that means is they say, pay us X amount and we'll take all the indigent defense cases for your jurisdiction. The problem is that because budgets are strapped, these wind up being low bid contracts. They go to the lowest bidder. So again, you have a situation where you have the same incentive problems. They're paid a flat fee. It's the lowest fee in order to take all of these indigent defense cases. And they have no incentive to spend, at least not a financial one, time on these cases. And the money that they get is often so low that they too have to get other jobs. And so you have lawyers who are spending 30% of their time doing their indigent defense contract work and 70% on private cases where they can actually earn money. And if you can take all of the indigent defense cases in a given jurisdiction and say that's only going to be 30% of my time, they're not doing investigation, research, zealous advocacy, talking to their clients, thinking about their clients' needs. So we have huge structural problems in the way that we fund the defense side in the system. So that's one thing. In a lot of cases, there is no defense attorney, or there's a defense attorney who's so drastically underfunded and overworked that he or she cannot do the job in the way that the system would normally envision. There's also another problem with that original picture. There aren't jury trials as a matter of course in our system. 95% roughly of defendants plead guilty. Like every 2 seconds in a typical work hour, someone is pleading guilty in a criminal court around the country. And in many jurisdictions, when you combine that phenomenon with the fact that you have these lawyers who are often appointed at the last minute and underfunded and overworked, it creates what many have referred to as a meet 'em and plead 'em kind of system, where lawyers will meet their clients and plead them out to the charges within often a 5-minute time period, which is kind of abhorrent if you think about the fact that they have no idea whether the person is guilty or innocent, or whether they've been overcharged, or what is the best resolution of the case for their clients. The pressure to plead in our system is enormous. I know Alec Karakatsanis came and spoke to you about the cash bail problems that we have in this country. The large number of people who are arrested are held in jail on a cash bail pre-trial because they are poor. We generally incarcerate poor people of color in this country. And if they don't have the money to get out, they will just sit in jail. And when they come to court, the offer from the prosecutor in a lot of these cases, because as I said, the vast majority of cases in our criminal system are misdemeanors, the offer will be, look, you can plead guilty now and get out of jail, or we'll continue this case for more preparation and you'll have to sit there if you can't afford your bond. Or you could go to trial and risk getting a higher sentence. And for a lot of alleged misdemeanors, whether they're guilty or innocent, what they want is to get out of jail. So they plead guilty to a misdemeanor charge of time served or something similar just to get out of jail. Even for felonies, the pressure to plead is enormous. I'll show you, this is from the Human Rights Watch from 2012. The average sentence for a federal drug defendant after a plea was 5 years and 4 months. But after a trial, it was 16 years. There is a tax on people in our system who assert their constitutional rights to a trial. They will be penalized for going to trial. And the defense attorneys know that this is going to happen. And the prosecutors are the ones who ask for those higher sentences, and the judges impose those higher sentences. So a lot of defendants, when faced with, they ask their lawyers, if they have lawyers at the felony stage, what could happen if I go to trial? And the lawyer tells them what the numbers reflect, which they have to do. And the defendant says, I don't want to take the risk. I'll take the plea, and I will, because it's a third of the sentence that I could possibly get if I go to trial. So the prosecutors also have the power to overcharge and stack multiple charges for one event. Take, for example, the following situation. Let's say you're standing on a street corner and a police officer comes over to you and says, you should leave, move on, that you're loitering, for example, or that you're being too loud and therefore disturbing the public in some way. Suppose you say, I have free speech rights. I don't want to go anywhere. I want to stay here and talk. And the officer says, you are now failing to obey my lawful order. I'm going to arrest you, and reaches for your arm, and you yank your arm away and smack the officer's wrist in the process of yanking your arm away. That criminal episode could be charged lots of different ways. You could look at that if you were a prosecutor and you could say, he was, maybe there was no crime there. Maybe he was exercising his constitutional rights and this was an abuse of police authority. You could look at a different prosecutor and drop the case. Another prosecutor could look at this and say, look, he was being disorderly in public, right? I'm going to charge this as a disorderly conduct kind of misdemeanor offense, very minor offense. Another prosecutor could look at this case and say, you know what? This guy was being disorderly in public. He failed to obey a lawful police order. He resisted arrest, and in the course of resisting arrest, assaulted a police officer. Now you've got potentially 2 felony offenses on top of those 2 smaller misdemeanor offenses. The criminal code is vast. Prosecutors have amazing discretion to charge however much they want, and it really can vary depending on the prosecutor involved. So when you add that overcharging to this plea picture, what it means is that individual, when he comes into court, is going to be told by his lawyer, well, you've been charged with assaulting a police officer, which carries 10 years in prison. You've been charged with resisting arrest, which carries another potential 5 years in prison. You've been charged with also these misdemeanor offenses of disorderly conduct and failing to obey a lawful order. Those carry less than a year in prison, potentially. The plea offer is plead guilty to the disorderly conduct and get a sentence of under a year, or go to trial and face all of that together. That's really scary, right? For a defendant to be told that, and those could be stacked, that you're facing 10 years plus 5 years plus 2 offenses. So the ability to overcharge also pressures defendants to take these pleas. And the plea process can be really crazy in certain courtrooms around the country. Here's an example. This is a sketch of what was going on in one courtroom, and I've seen this in other courtrooms, where they bring in a line of individuals and they do group pleas where the judge says, you're all planning to plead guilty, right? And they sort of in unison say yes. They have no idea what's going on. And often it's done en masse in some courtrooms. Even when it's done individually, I have seen some really gross abuses of power. I saw one situation where a judge said, my understanding is that you're here to plead guilty. And the defendant said, no comprende in Spanish, like, I don't understand. And the judge said, oh, you want to plead nolo contendere, which is a Latin phrase for a kind of plead that translates to saying, I don't contest the charges. And everyone in the room did nothing until, like, I went up to the clerk and said, I don't think he understands what's happening in this system. So we have a situation where there's all this pressure to plead. There's a lot of abuse. And it's not surprising if you see in this picture, these are all Black and brown faces. Because if you walk into a criminal courtroom, the people who are being dragged through this system and put into these cages are Black and brown people from poor communities. And they're not being given defense lawyers who have the time to actually represent them. And they're not being given jury trials where their peers can actually scrutinize what has happened to them because they're being pressured to plead. Last thing, right, that I want to say that is not true about this picture is there's not a judge at the front of the room who is ensuring that everything is fair as this system unfolds. In most states, judges are elected. 24 states don't require judges to have law degrees. They need to process cases quickly and efficiently in order to get through their dockets. And if you go to courtrooms, you will often see judges who are often former prosecutors. There are very few former defenders on the bench, trying to push to resolve these cases quickly. And when a defense lawyer says, like, I haven't had time to do what is required to investigate this case, you're going to see a lot of judges say, well, we're going to resolve this today, rather than understanding that something needs to be done. And this is a problem in a lot of respects, even in these what people think of as more dinky or misdemeanor cases, because what happens when someone is convicted of a misdemeanor, right? They're given fines and fees, which can be devastating. And if they can't pay them because they're poor, they can wind up back in court being held in contempt for failure to pay. This is a report from Ferguson. It's not just Ferguson, that's everywhere that you have these fines and fees. It's the same problem we have with cash bail in keeping poor people in the criminal justice system. And then there are the collateral consequences of any criminal conviction, whether it's a misdemeanor or a felony. You've got individuals with even a minor misdemeanor drug possession. They have adverse effects on their ability to get jobs. They can't get business licenses. They can't get certain property rights. They can't get professional licenses. They can't participate in government contracts. They can't get government benefits like food stamps or housing assistance. They can't get student loans sometimes, depending on what the conviction is. Often there are registry requirements for a lot of misdemeanor offenses. Sometimes they can't participate in political life, or they're stripped of their right to vote. They can't serve on juries. They can't get into certain schools. They lose custody of their children because of their involvement in the criminal justice system. They can't possess weapons or other recreational licenses. They will lose driving privileges in a lot of circumstances. Like, this is a slow civil death in a lot of situations for people who get criminal convictions. So a lot of people focus, and when they think about criminal justice reform, on felony offenses, because they think these are the big offenses that contribute to mass incarceration. And those are problems. But the misdemeanor system is equally problematic and has devastating effects on people's lives. All right, so what happens when you've got no trials to bring about the facts, even in felony cases, because everybody pleads, and the defense lawyers are not there to raise doubts and do the job that the system envisions? Well, you get mass processing of poor people of color into prison, and you have no check on the low visibility and highly discretionary police activity that goes on in and around this country. If you have police officers who are racially profiling, the system doesn't check that because the cases don't ever see the light of a trial. If you have police officers who are arbitrarily stopping individuals, it takes a very long time for anything in the system to happen, because if they're doing it at the misdemeanor level, it remains hidden from view within our system until a civil rights organization picks up on it and finds a way to bring a large class action kind of lawsuit. You also have just sort of what I would call random. Like, is it a good day or a bad day? If the witnesses show up on a certain day, the defendant is convicted. If the witnesses don't show up, the defendant may be let off, right, in that circumstance. If the victim is really upset and the prosecutor defers to the victim, suddenly the potential jail sentence gets higher. And if you've got a quieter victim, lower. Some judges are tougher than others, and some judges will give probation for an offense, and another judge might give 5 years for that offense. And racism and classism infect the entire system. It also means that you have a lot of innocent people who can be convicted in our system. The data from the National Registry of Exonerations supports this and says, look, 18% of the exonerations that they recorded were from guilty pleas, right? People who are innocent will plead guilty because of this pressure. And though we've got a lot of data on exonerations from DNA projects and innocence projects for felony offenses that they can reinvestigate years later, one can only imagine how many innocent people get swept up into the misdemeanor system, given all the pressures that I've already talked to you about. All right, last thing that is really troubling about this system is how indifferent we as a society have become about what happens. If you go sit in a criminal courtroom, I don't care where you are, if you go sit in a criminal courtroom, you're going to see a similar picture. You're going to see Black and brown people being brought in, weird language that's very legal being spoken sometimes, and then they're going to be handcuffed and taken off to jail and prison. And what you're going to see is sort of like a blindness, a numbness. It's as though like these aren't human beings who are worthy of dignity and respect, because it's just a system and it's just an assembly line and it's just processing. You have situations like the one I described where there's a man who's saying, I don't even understand what's happening in my case, no comprende. And nobody in that room blinked. Not the court reporter, not the judge, not the prosecutor who's supposed to be seeking justice, not the defense lawyers who are supposed to be representing their clients, not anyone in the gallery. Like, this is just par for the course, because that's what happens in our criminal justice system. That kind of numbness is a cultural problem, right? We should not be okay with just having sort of legal phrases uttered and imprisoning people in less than 5 minutes as their lives are taken away and their families are affected. Many people have no idea exactly what happened in that courtroom. No one explains it to them. All they know is that they see members of their community just being imprisoned. And because of that, there's a huge sense, I think a correct sense among many from poor communities, that there is no procedural justice, that the law is not fair, that the law is not just, that the system is stacked against them. And it's hard to have respect for a legal system if you don't feel like the procedures that that system uses are designed to actually get at just results. How did this happen? I mean, so one thing I think that is really important to remember is that Gideon versus Wainwright case that gave everybody a right to a lawyer. It was always an unfunded mandate, right? The Supreme Court can say that people have the right to effective lawyers to sort of present their side and fight against this assembly line of people into prison. But the Supreme Court doesn't control funding decisions. The state legislatures do. So it's never been an adequately funded right in our system. And as a result, right, when you underfund or defund something, it takes away the ability of that something to do its intended purpose. We also have a situation where, if you look historically, we had an expansion of constitutional criminal procedure rights in the 1960s when the Supreme Court under Chief Justice Warren's leadership began to see that there were problems with predominantly how Black and Brown Americans were being treated in this country. And they started to expand the constitutional rights that those individuals would have. But then that was counteracted in the 1970s when there was the war on drugs. And, the government thought that was the main source of the problems. The legislatures enacted these draconian penalties for drug offenses, and they funded police departments to go and try and put a kibosh on drug trade. And it wound up being a situation where lots of police officers were arresting a lot of individuals for drug offenses, and they were getting incredibly long sentences because the legislature had said this was a war on drugs and we needed these long sentences. And it filled the prisons with Black and Brown people, starting from the 1970s on. And we've never fully gotten out of that. The courtrooms became clogged. Plea bargaining then became essential because there was no way that they would be able to dispose of all of these cases, giving everyone their right to a trial. And one of the ways they could induce these pleas was the legislature imposed these mandatory minimum sentences, expanded the criminal code, gave prosecutors the ability to stack a bunch of charges, as I talked about earlier, that could lead to higher and higher exposure. That gave the prosecutors a lot of leverage and enabled our plea bargaining system to become the predominant way in which we resolve criminal cases in this country. And many of these prosecutors were elected for being tough on crime. They were, in many offices, promoted based on their conviction rates or the lengths of the sentences that they could get. And it was a very punitive culture that developed as a result. Now, flash forward, right? We now have a situation where we incarcerate more people than almost any other country in the world. It is costing us an incredible amount of money to do it. There is a lens or a spotlight being shown on both police brutality vis-a-vis minority communities and racial profiling vis-a-vis minority communities. And you have sort of a bipartisan view that we need to reform the criminal justice system somehow. Because even those who are on the right, who are the more conservative wing, whether they're libertarian or Republican or just conservative on criminal justice issues, tend to see the drastic costs that we are imposing and the inefficiencies that currently exist in our system. Those on the left who are upset about the racial injustice and the imprisonment of individuals can come together toward criminal justice reform. So one question, which is I think one of the big things you in your debate program are here to try and answer, is how do you fix this system? Right? So I want to turn a little bit to discuss that. I wish I could tell you that there was one sort of like silver bullet answer that would fix the criminal justice system. But when you're dealing with a systemic problem, any systemic problem, there's not going to be one solution. This is a multifaceted problem that will have to be addressed from multiple angles in order for it to be solved, resolved, or helped in any way. Part of what's going to make this hard is you're going to need all three branches of government to do something: the executive branch, the legislature, and the judges. And what's even more complicating on top of that is the federalist system that we have in this country. So what do I mean by that? We have a federalist system in this country that says, look, there are certain things that are part of what our central executive government branch will do, the federal government. And there are other things that we leave to the purview of the states, because the states have individual interests. They have unique needs, unique desires, and they have certain things that they have more purview over. And criminal justice is predominantly run by the states. Federal criminal justice, federal criminal prosecutions, federal criminal crimes is actually a very, very small sliver of the criminal justice system. The vast majority of what winds up being criminal justice in this country is done state by state. Each state gets to define its own criminal code. Each state gets to define its own penalties. Each state has its own system for providing for lawyers for the defense, and each state has its own way of choosing its judges. So layered on top of the fact that you need to have action from all three branches of government is the fact that you need to have local action at the state level, and that the federal government can do things to lead by example, right? Or the federal government can do things to trigger or catalyze or incentivize state action. And sometimes it can do a little bit of direct regulation, but it is limited because criminal justice is more of a state sphere. So I want to talk about each branch and talk about the state and federal possibilities, and then I would be happy to take your questions and have more of a conversation with you about it. Okay, so let's talk about the executive branch, because this is a big thing right now. Right now, this is all the rage. We've got all these progressive prosecutors, right, from Larry Krasner to Chesa Boudin, right, reformers who want to change our criminal justice system. Many people think this is the solution, right? That prosecutors have an immense amount of power in the system. They're the ones who decide what charges to bring. They're the ones who decide what sentences to seek. They have the ability to seek diversion, meaning like take things out of our prison system and try to resolve things short of prison, whether it's through programming, whether it's through restorative justice and the prison abolition movement. Like, prosecutors have all of this authority to fix the system. I think the progressive prosecution movement is great. I think it's important. I think it's limited. I don't think this can be the only response. And there's a couple reasons for that. One is what I'm going to call the Willie Horton effect, right? Progressive prosecutors are elected, and at a time when the electorate is upset about discriminatory treatment, is upset about abuse of power, is upset about mass incarceration, there's a move to elect progressive prosecutors. But what will happen is, suppose a progressive prosecutor is part of either not charging or releasing an individual from prison, and that individual does something bad. Right? Just given the numbers of people we're talking about, somebody's going to do something bad, right? So that individual commits some heinous crime. And what will happen is the opponent of that prosecutor in the next election, who's going to be more of a tough on crime kind of person, is going to say, this person let off a criminal who then killed someone in some terrible way. And we've seen historically this cycle with elections. It's never politically popular to be soft on crime, especially when you can make that crime about a child victim or about a horribly violent offense. So progressive prosecutors can get elected in, but they can also get booted out based on sort of the whims of the electorate, which are very, very subject to this kind of visceral, emotional charge of committing an offense. So the question of how long their tenure will be is one potential issue. Another potential issue is where they can get elected, right? San Francisco electing a reform prosecutor is not surprising. San Francisco has a very progressive electorate, but there are certain places where it's going to be very hard for a reformist prosecutor to get elected. And the question will still remain, what should we do in those jurisdictions? There's also this sort of response to the progressive prosecution movement, which is they do have a lot of power, but they do not have unilateral power in the system. There are many forces that operate within the criminal justice system. And if you watch what some of the progressive prosecutors are trying to do, some of their efforts are being stymied by other criminal justice actors. So, for example, they can't control the police. They can say, I won't bring the charges, but the police can still arrest whoever they want to arrest, target whoever they want to target, and then just have those charges not be brought to fruition. They can't control the judges. A lot of judges will not allow prosecutors to withdraw cases that have already been filed because they don't like the progressive movement of that prosecutor. So they hit a lot of resistance. Sometimes they have cultural resistance within their own prosecutors' offices because you've got a combination of prosecutors, some of whom have reformist ideals and some of whom are more tough on crime ideals from the past. And you have to deal with the tension. And maybe it means cleaning house, as some progressive prosecutors have done. But in other situations, like there are situations where they have to coexist and there can be internal political problems within a prosecutor's office. So I think the move toward progressive prosecution is a good one, but it is not the end-all be-all solution. Some people have said, okay, like in addition to that, we need to deal with the police, because I mentioned that the prosecutors, although they can incentivize police action, can't control the police. And this is a big topic of current reform in light of what has gone on with the protests with Floyd, with a lot of individuals who've been mistreated and often killed by police around this country. People say, look, we got to change the culture in police departments. We need better training for police. We need different mentality. We need police departments that don't have more of a militaristic crime control approach. We need them to be more community policing oriented. And there are lots of proposals for how you could bring about a change in training of police officers, whether it's defunding a department and starting over, whether it is cutting the budget, whether it is reprioritizing the budget and trying to take on a different training approach, a different supervisory approach, a different relationship with the community that those individuals are policing. That's another executive branch function that we could look at. So we could look at more reform prosecutors. We could look at better cultures in police departments. We also could look at like the charging and plea bargaining process, which is largely unregulated in our current system and which leads to a lot of these issues being swept under the rug, no trials, just these quick 5-minute pleas. We could have guidelines on charging. We could say, as some prosecutors have, I'm not going to charge certain offenses. I'm not going to charge mandatory minimums. We could have them explain what their plea bargaining process is going to be to make it more uniform. We could have more diversion out of the criminal justice system, more action toward restorative justice, where we can try and solve problems short of putting people into the prison system. So that's another possible way that we could see executive action come into play here. Most of what I've described is going to be at the state level. You can do it at the federal level for federal criminal prosecutions, but again, I'm going to say that is a situation that is a very small slice of the criminal justice system. The federal government could incentivize this by channeling money into state police training and reorganization, into guidance, into progressive prosecution. They have a couple of ways to do that. They can create task forces that are designed to investigate this and provide information. If it's going to be money directly, it's going to be legislatively allocated. But sometimes if the executive branch has certain buckets, it can think about how to prioritize grants from the executive branch toward certain initiatives like police training or progressive prosecution. But the legislature will have to be involved in more direct ways. So as I mentioned sort of at the beginning, we kind of need to rebalance the system. We have to fund indigent defense in this system if we expect it to work. I said earlier, look, the progressive prosecutors will come and go because they are beholden to the electorate. And we cycle historically through being tough on crime, and it comes back regularly whenever there's a spike in criminal activity in a jurisdiction. There's one actor in the criminal justice system whose entire role and purpose is to represent and give voice to the voiceless, to represent the criminal defendants, to fight against criminal charges and ensure that no one is railroaded. And that's the defense lawyer. The problem is that a lot of defense lawyers, though well-intentioned, cannot perform their intended constitutional function because of the lack of funding, because of the lack of structure in certain states where you have these assigned counsel systems of disparate lawyers all over who don't have combined resources, who don't have mentorship and supervision and training. If we had robust defense function in this country, what you would see is a lot more fight in court, a lot more, look, you cannot deprive people of their constitutional rights on my watch, a lot more standing up for the rights of the communities who are adversely affected by over-policing, a lot more standing up for and fighting for the Black and brown communities who are affected by overcharging. And you would have more legitimacy infused into the system. You also would probably have fewer wrongful convictions, because if you had lawyers who could do investigation and do the research necessary to find out that this person actually had an alibi and could point that out to a judge, a jury, or a prosecutor, you might be able to get rid of those cases and get them out of the system rather than have people being pressured into going forward with these cases. So one, I think, really big reform that has to happen is buttressing the indigent defense function in our system. That can be done through legislative allocation of resources. Some of that will have to be done at the structural level of how indigent defense is provided. If you have a statewide public defender agency that can provide centralized training and oversight, you're going to have a much better system than if everybody is sort of left on their own to fend for themselves. Other things the legislature can do, and some of these are happening in different places around the country already, is decriminalizing a lot of more minor offenses. We have, the criminal code, if you just pick up your state's criminal code and you read through it, it's unbelievable how many things are crimes. And many of which are sort of order maintenance offenses at a lower level. Like, we all agree we're going to have homicide as a crime. Nobody was going to say, let's make it okay to kill people. But there are a lot of crimes that we could get rid of. And you see a lot of states doing this. So, for example, drug possession offenses. A lot of states are decriminalizing marijuana possession. A lot of states, traffic offenses. This is a huge gateway into the criminal justice system because there's a lot of documented evidence of police officers engaging in racial profiling to stop individuals of color, and then under the traffic code, and then performing searches or asking them for consent to search and finding other things, or just arresting them for traffic infractions. So there are a number of states where they will decriminalize some of those traffic infractions to get those out of the system, and they can clear off large parts of their docket by doing it. There was one county in Minnesota that decriminalized driving on a suspended license, and that was like a third of their docket in that jurisdiction. So decriminalization is another thing the legislature can do. That would ease a little bit of the burdens on the system, which would enable for more potential and better representation of defendants and more time per case in our system. Eliminating mandatory minimum sentences is another important thing. We've seen some movement in the First Step Act at the federal government level with respect to this. We could see more movement at the state levels on decriminalizing things and also eliminating mandatory minimums. The minimums are part of what enable the prosecutors to stack these charges in ways that exert pressure on defendants to plead guilty. So if you cleaned out the criminal codes and took out those mandatory minimums, and you had guidance at the executive level about charging, you might be able to get rid of some of this overcharging phenomenon that feeds the plea machine of our system. And then there's another thing, right, that you might be able to do. I don't know how many of you have seen this statute. This is a federal statute. It's known as Section 14141. This is a statute that allows the United States Department of Justice, under the Attorney General, to go in and file federal enforcement actions in states, counties, municipalities throughout the country where there are systemic violations of individuals' criminal procedure rights by police officers. Right? So these investigations are very effective when they are filed because the Department of Justice has a lot of gravitas, has a lot of resources, has a lot of cachet at a local level. So when the federal government comes in and it files a lawsuit against a police department and says, our investigation reveals that there's a pattern and practice of your police officers engaging in racially discriminatory stops, or there's a pattern and practice of your police officers engaging in excessive force. These are lawsuits that ultimately typically wind up settling with plans where there is a plan put in place for progress going forward, and usually someone instilled as a monitor to look at what exactly is going on in that police department, and a regime of data collection to ensure that the department improves over time. And we've seen these. The Ferguson reports that many of you probably read after the Michael Brown incident were the results of 14141 investigations by the federal government. Under President Obama, there were many more 14141 investigations of police departments around the country. That has really almost stopped under President Trump, but that power exists. And so it's one of the biggest powers the federal government has to sort of reach out and intervene in local state criminal procedure. I think there needs to be more of it on the policing front. There also could be a legislative expansion of this to include the provision of indigent defense services. Arguably, that kind of does exist for juvenile cases. Oops, sorry, let me go back. Because there is this language here that says the administration of juvenile justice. So they can actually go in now if there's in juvenile justice systems inadequate lawyers being appointed and bring a 14141 lawsuit based on that. I think they should do that. I think they should also expand the legislation to have the federal government looking at how states are providing for the right to a lawyer in criminal cases and file these enforcement actions. On the one hand, these are great because, as I said, the Department of Justice has these resources and has the gravitas when it comes in to try and shake things up and get things done. On the other hand, the downside to this is they're very time intensive and resource intensive to do. And how effective they will be over long periods of time really depends on what kind of consent decrees come out of them, what kinds of agreements are in place, and how much improvement and how much monitoring there is of the police department or the indigent defense organizations afterwards. You have to stick around long enough to make sure there's cultural shift, because if they pull out beforehand, then things can revert back to where they were. So that's another thing the legislature at the federal level could do that could affect the provision of services at the state level. And then there's the judiciary, right, which is an important last part. I mean, I know Alec Karakatsanis probably spoke to you about the need to end cash bail. That is a huge need in our system. It's just not, bail is supposed to exist when someone gets arrested to ensure that they don't flee and that they don't pose a danger to other people. The money part of that is not actually going to serve those ends for most criminal defendants. And for the most part, given the technology that we now have, there are so many other ways to ensure that people appear for court. There actually are studies in this country about just texting people to remind them of their court dates drastically increases the incidence with which people wind up coming to court when they are supposed to be there. When you're dealing with a system where over 80% of the people who are charged are poor, the flight risk concern is relatively minimal. They don't have the money or the connections in other places oftentimes to flee. The issue is, will they come? And sometimes what prevents them from coming is they forget, number one, or two, they don't trust the system, right? They think if they come, they're going to be railroaded. And if we can improve on a lot of the things that are going on in the system so that they think they can come and get a fair shake, you're going to see more people coming to court. You also need the judiciary to serve as a check more so than it has on many other aspects of the system. So many of you probably, when you think about judges, you think, okay, they're there to check the legislative and executive branches. So if the lawyers are not being provided by the state, the judiciary should respond to that. If the lawyers are so ineffective because they don't have any money and they don't have any funding and they're overwhelmed with cases, the judges should fix that. Or if you have prosecutors that are doing bad things in the system, like withholding evidence that shows a defendant is innocent, which happens in our system. At least I think 37% of our exoneration cases are cases where later they found out there was a prosecutor who withheld something from the defense that would have demonstrated potential innocence. So if you think there's prosecutorial misconduct or defense attorney misconduct, or like a lack of investigation in these cases, that is something the judiciary is supposed to check, right? The judiciary should say, we're not doing this right. So why isn't the judiciary doing that? Well, and this is the last thing that I think they asked me to cover when I spoke to you. Many of you may have heard of a system called habeas corpus, but you might not know so much about it. Here's what a chart that tells you how criminal cases actually get handled in our jurisdiction. So most of you know, right? Most cases start in a state trial court, right? If you're convicted of a crime, you have an automatic right to appeal to the intermediate state appellate court in your jurisdiction. And if you lose there, you can try and get the highest state court to hear it or go up to the United States Supreme Court if you have a federal issue in your case. What most people don't know until they study the system is that this appellate process, which is known as direct review, is in most places a process that is reserved for what we call on-the-record claims. So what does that mean? It means when you file an appeal in most states, what the judges on appeal will do is they will look at the transcript of what happened at the trial. They will not go beyond the four corners of that transcript. So if the transcript indicates that there was an objection that somebody made, that the judge overruled, that the judge shouldn't have overruled, they will fix it because that's an error in the transcript that you can see in the trial. What they won't do on direct review in most jurisdictions is go off the record or outside that record and try and figure out what went wrong, not in the court proceeding, whether it's a plea or a trial. Now you can start to see the problem. If the problem is that the prosecutor withheld stuff or did something bad, that's not clear on the record. That's stuff that happened behind the scenes. If the problem is that the defense lawyer didn't investigate or didn't do any research or didn't meet with his or her client beforehand, that's not something you'll see in the transcript. That's off the record. A lot of the problems in our criminal justice system are about what happened before the stuff that happened on the record. And the problem is that our entire appellate system doesn't address that. You have to wait till after you go through appeals to go into what we call collateral attack or habeas review. And you start at the state trial court again, and you say, I've got now off the record claims that I want to raise. And I want you to tell me that I'm being held in violation of the Constitution because I didn't have a lawyer like the lawyer the Constitution requires. Or I want to show you that there was prosecutorial misconduct. Or I want to show you something that you couldn't see on the face of that trial record. You'd start in the state trial court and ask them to hear it, go up through the state system. And if you can't get your claim heard there, then you would file what's called a federal habeas corpus petition in the federal district court. That's what habeas is. Habeas is the federal court reviewing the state court's determinations and asking whether the state court's determinations resulted in you being held in violation of your federal constitutional rights. Couple problems here. One, there's no right to lawyers for these off-the-record claims. So a lot of times, defendants, the only right to a lawyer you've got in our system is at the trial and on this first appeal. After that, if you're poor, there's no constitutional right to a lawyer. So what does this mean? It means if you get a long prison sentence and you want to say your lawyer was ineffective or that the prosecutor did something wrong, you have to reinvestigate your case from your jail cell without a lawyer's assistance unless you have money to do it, and try and get the state court to hear you. State courts often don't give hearings at this stage, like the records don't get developed. And when you go into federal habeas corpus review, you're now years later. It can take 4 years to get through appeals in some jurisdictions. Then you've got to get through the state collateral part, and then you go into federal court for habeas review. And by then, a lot of evidence has disappeared. You still don't have a constitutional right to a lawyer for the federal habeas corpus hearing. So effectively, the structure of our system, by not letting us open the record earlier, means that we've hidden all of these problems in parts of our system that happen years after a conviction, where you don't have a right to a lawyer and you have to kind of do it on your own. It makes it much easier for the judiciary to not address the problems. So one thing that we could do is move some of these claims. In a small handful of states, they will allow you to open the record on that first appeal and look at things like what happened with the trial lawyer, with the prosecutor. Is there an injustice that needs to be corrected? If you moved those record opening situations earlier, where there is a right to a lawyer, where the evidence still exists, where the situation is still fresh, you'd shine a light on a lot of the systemic problems, and maybe then you'd push the judiciary to act. Now, it's possible the judiciary would just shut you down. That's always a possibility. But without ever forcing the issue in front of the judiciary, we'll never know. So that's another way in which the judiciary could get involved. There's also, for those who study the habeas system, many think part of the problem is at the state level here, you have a lot of judges who are not willing to buck the trend of mass incarceration. And people think, well, the federal judges, right? Like they're more removed. There's a better selection process for them. They're not elected the way the state judges are. Maybe they would be better at enforcing the Constitution. But there are a lot of procedural obstacles to letting the federal court interfere with state court criminal justice. And that goes back to that point I made at the beginning when we talked about reforms, which is we have a federalist system. There's a sphere for the states and there's a sphere for the federal government. And this criminal justice world has been delegated in many respects to the states. So if the federal courts are going to come in and try and say what the states did is wrong, there's a lot of obstacles to doing that. And so one thing we could do is remove some of those obstacles. Those are legislative obstacles. There's a statute called the Anti-Terrorism and Effective Death Penalty Act that was passed shortly after the Oklahoma City bombings in 1996 that limits the ability of federal courts to hear a lot of these claims. And so that's another way to open up this post-conviction review and think about having the judiciary perform a larger role. All right, I've hit you with a ton of information. I'm going to stop the screen sharing now, if I can. Let's say. And I'm happy to hear your questions and see if I can help.
All right, so we have a bunch of questions.
All right.
And I will kind of start with the first one, which is, do you think that drafting a new uniform prosecutorial system that is based around protecting against violations of due process would resolve some of the problems that you were describing in the prosecutorial system?
Well, I don't think you can have a uniform prosecutorial code. And that's that federalist system. Every state gets to decide. The only way that the courts can require things is if they violate the Constitution. So if you created a prosecutorial system that we thought was running afoul of constitutional rights, the court could, in individual cases, step in and say no. You could also have a civil rights organization that brings a civil rights cause of action, which is similar to a 14141 kind of thing that the federal government could bring, but it's called 1983 if it's a state actor, or Bivens if it's a federal actor. They could file lawsuits and try and say, we think that the prosecutorial system is problematic and violates the Constitution. There's a lot of immunities for prosecutors. I know immunities for police are hot in the news right now, right? But there's almost absolute immunities that prosecutors have for the work that they perform on the job. So it would be hard to go after them for money. You might be able to get some form of injunctive relief where you would have a monitor who would get them up to constitutional standards. But that's all just the baseline of if they're violating. You could try having the federal government adopt a prosecutorial policy with respect to overcharging and plea bargaining that has a signaling and modeling effect that other states may choose to adopt, but you have to do it sort of as a campaign state by state, because there's no way to impose it as a uniform matter unless you had a situation where the federal government was really willing to put its money where its mouth was, right? Which I don't think this is going to happen with this federal government, but you could have a situation where the federal government said, look, every grant that we give the state is conditioned on your accepting these uniform prosecutorial standards. And though that doesn't, quote, force the state to do it, it really incentivizes the state to do it. So you could do that, but it would have to be a really high priority. And one of the problems is, though there is bipartisan support for some criminal justice reform right now, like criminal justice always loses to certain other issues when it comes to things like funding. Like people want hospitals, particularly in the COVID crisis, right, to have funding. People want education to have funding, right? Funding criminal justice never seems like as important as some of those other things. So it's going to be hard to make that like the top priority to incentivize states to do it.
So I actually have a follow-up question based on something that you mentioned in there, which is about the question of immunity and whether or not you think that either that legislation that curbs that level of immunity for either prosecutors or police, do you think that that would be an effective reform? And, you know, in what parts of the system do you think that that would be most effective at reforming?
Yeah, I think, again, I think, as I said, like this is such a systemic problem that you're going to need reform at multiple levels. Removing qualified immunity would be good, right? For a number of reasons. It would be good because if you want to think of the judiciary as checking what is going on in the police departments, for example, qualified immunity is a doctrine that basically says we will not even have to adjudicate whether what the police officer did violated the Constitution unless the violation is just absolutely obviously clear. And the problem is that most of the law that regulates police officers is through standards, right? Standards of reasonableness. These are things that are never clear. I shouldn't say never. I mean, some things are clear even with a standard, but they are less often clear, right, than rules are. And so when you have qualified immunity, what it means is a lot of times the courts will say, we don't have to say whether what the police officers did was constitutionally okay or not. We just don't think it rises to the level of getting past this qualified immunity barrier. And so you don't get any dialogue from the courts about the scope of what is problematic about what police officers do. So it would lift that. I think it also would incentivize the police departments to train. Now, a lot depends on what the indemnification models look like in the police departments, right? Like if a department is held liable and has to pay money, and that money actually comes from the state coffers because of the indemnification rules, such that the officers don't feel anything, then you're relying sort of on pressure coming from a later point. But assuming that there's going to be some pressure that comes on a police department to comply, then if you get the removal of qualified immunity, it's going to incentivize them to train, to supervise, to ensure that they're not having more violations because it hurts them to have it. The flip side is there are people who believe that it will unnecessarily chill. Like police officers won't do things that are needed because they'll be so scared, right, of violating the law. Personally, I'm not so worried about that. I think especially in the short term, pulling back, I think would be better. I think the bigger concern that I think is a legitimate concern is the concern that you will not get nearly as many police officers or nearly as many people applying for the jobs. It is hard to find in a lot of jurisdictions people who want to be police officers, who have the orientation that a reformist police department might want to have. And often it depends on where you are. It varies dramatically. Some police officers are very well compensated, but in a lot of places, police officers are very poorly compensated. And if you add to that they could be personally liable if they make mistakes, I think there are some officers who will say, like, look, I just can't, I got a family, I can't take that risk. And you might have just fewer people who want to do it. Maybe that's good because you'll have smaller police departments. It's a way of shrinking down what we're doing. But these are the kinds of considerations I think people would have to think through. But for clarity in the law, for guidance, I think the elimination of these immunities would be good.
Sounds good. A couple of other questions. A couple questions about guilty pleas.
Yeah.
So the first is, are there any estimates for how many guilty pleas happen for people who are actually innocent? And kind of why would someone agree to plead guilty if they are innocent?
Yeah, so as of January of 2017, the recorded exonerations, I think as of January of 2017, they had 1,956 recorded exonerations in the National Registry of Exonerations. 343 of those were from guilty pleas. So that's 18%. So there is evidence that people who are innocent, who are later proven to be innocent, right, plead guilty. Why? It's the reasons I talked about before. It's the pressure, it's the fear, it's the distrust of the system. I guess I would put it back to you this way. Let's say you're not guilty of committing a crime and you're picked up and you're put into a jail cell and you're held there and you're told you're facing a murder charge, like a really serious charge. And you're like, I didn't do this. And then no lawyer shows up. They say, we're appointing a lawyer for you because you're too poor to afford one. And no lawyer shows up. You're waiting. Like, where's my lawyer? 20 days pass, 30 days pass, 60 days pass, 70 days later, a lawyer comes in, says, hey, I'm going to be your lawyer. Here's the situation. These are the state's got all this evidence against you. They say this and they say that, and they've got this scientific forensic evidence that locates you at the scene, and they've got 2 eyewitnesses who are going to say that you did this, and they're offering you a plea where you could spend 10 years in prison or you could face the death penalty. And you think about that, I got 30 other clients to meet. I'll be back here in a little bit and we'll figure it. And you're like, well, wait, I didn't do it. He's like, okay, well, what do you mean you didn't do it? Who's going to say you didn't do it? Well, my cousin. Oh, your cousin. They're going to know he's your cousin, right? Do you think they'll buy that? And say, suppose you leave and that defense lawyer hasn't done investigation for you, hasn't given you much confidence that he or she will be able to do investigation for you. The evidence that gets presented to you, it looks scientific, right? They've got some weird hair and fiber analysis that somehow places you at the scene, and you have no idea how that's true because you weren't there, but it looks pretty good that the jury is going to think you were there. And your options are 10 years or the death penalty, right? People will plead guilty even if they didn't do things, especially because they will also think I can challenge it later. Maybe if I challenge it later, I'll get a different lawyer who will be able to show. People don't understand the system and how hard it is to challenge a conviction. Or they think look, I don't want to die. I don't want to be executed. And death row, even if you don't die, it takes years and years to be executed on death row in this country. But death row is not a fun place to be. Right. And so maybe you'll say I'll take the prison system where I, have some semblance of freedom. I'm not locked in one cell at all times. There's a rec yard. These are the kinds of choices that people are often forced to make. Sometimes, and I will add in, here's a whole nother dimension that you might think about. A lot of the people we bring into the system are young and have emotional and mental disabilities. And they are overwhelmed by the professional actors in our system who come in, the police officer who comes in and says, I can place you at the scene. I have seen interrogations of innocent defendants who have a mental disability or who are young, where the police officer will say, you were there, you killed her. And then he'll say, I don't know what you're talking about. I wasn't there. And then they start feeding the individual details over the course of the interrogation. This is a process known as contaminating a confession, right? And they say, well, first you did this, because it's the story that they think their evidence will piece together. And then they try to get you to parrot it back. And after 18 hours in that room, many people will say, how could somebody who didn't do something falsely confess? And I think what a lot of people who've been in that situation will say to you is, you sit in a room for 18 hours where they're just berating you and pushing you. And imagine that you don't have the education that you guys have. And you don't have the support system that many of you grew up with. And you have emotional and mental disabilities, right? Or a susceptibility to suggestion. And at the end, you feel like, I'll say anything to get out of this room. And sometimes some suspects wind up being convinced by the cops they must have done it. Like, maybe I don't remember it. Maybe I must have done this if you have all this evidence. And sometimes some suspects think, fine, I'll say whatever you want. It'll never hold up in court, because once I get a lawyer, I'll be able to show I didn't do it. But they don't know that either they won't be given a lawyer, or the lawyer will be overworked and underfunded. And so there are just so many problems that can lead to people saying something that then winds up looking like rock solid evidence that they committed the crime. So I think there's lots of reasons why innocent people will plead guilty, even to felony offenses. For those misdemeanor offenses, it's really easy to see how people would plead guilty, right? Like, they've been held for 30 days in jail. It is horrible. They haven't seen their families. They need to provide support for their families. The prosecutor says time served and you're out. They're not thinking about all those collateral consequences I showed you. They don't even understand, a lot of people. And I'm not saying that like in any way to suggest they're not intelligent. It's just like, if you're not a lawyer, you might not have studied these collateral consequences. And all they can think about is, I want to get out of jail now. My family needs me. I'm going to lose my job. We've got to pay rent, or we're going to lose our housing. And what they're saying is, I can get out now. I don't care if I have a conviction on my record. And keep in mind that when you over-police certain communities, what's a conviction on their record doesn't mean to them what it means to you. Almost everyone in their communities has convictions. 1 in 3 Black men are imprisoned in this country by the time they reach the age of 30. So like, they grew up in a system where getting into the system is part of what is expected in their community because of the way they're policed. So it's just you have to inhabit what it is like. And I mean, obviously you can't, right? But you have to try to understand what it is like to grow up in poverty in an over-policed community where everybody goes through this system. It has different valence to you when that's the case.
So what do you think is the best way to either reform, get rid of, or change the plea bargaining system in a way that would make it fairer and more effective?
Yeah, I think there should be a number of different things done to affect plea bargaining. All right, so one is a lot more transparency. One of the problems, now there's double-edged swords to this. Like, so for sentencing, I know many of you are studying sentencing too. In sentencing, it used to be like, okay, there are all of these racist and discriminatory and disparate sentences depending on the judges. Like, one judge gives you, nothing, the other gives you 20 years. And so the Sentencing Commission tried to create these guidelines that would try to sort of hem in all of that discretion. And there's like a big grid, if you ever look at sentencing guidelines, about what are the characteristics of an offender and what are the characteristics of the crime. And you find the box and it gives you a range. There are good things about sentencing guidelines and there are bad things about sentencing guidelines. And that's going to be true regardless of what you do. But plea bargaining, it's like, if the prosecutor is supposed to be accountable to the people, but the people have no idea why the prosecutor is making the decisions that he or she is making about plea bargaining, or why one individual is given X offer and another individual is given Y offer, or if they don't have to justify why they're charging 10 crimes as opposed to 2. Like, all of these things are things that, like, you would think if they made them public, that there would be the opportunity for a feedback mechanism. Now, I'm not going to sit here and kid you into thinking that many people would read public charging documents, right? And I'm not going to even say that there's going to be a lot of people who really care about this, because one of the big problems is when you target poor communities that often are disenfranchised because of their involvement in the system, like you aren't beholden to them. So if you're being elected, you don't actually have an incentive to care about what their opinion is of you. And a lot of wealthy white people don't care about the criminal justice system because they think they won't be impacted by it. So on the one hand, I think, yes, you want that more transparency within the executive branch itself. I think that would be good. I don't think that's going to do nearly as much. I'd do a couple of other things. I think there should be, rather than giving a line prosecutor charging decisions, I would put together a panel of people, and I'd include a defender, not somebody obviously who is currently a defender, but like a former defender on that panel to try and think about how you should assess a situation, and maybe a couple, just to get out of the myopic focus that sometimes the prosecutor's office will have. I mean, it's not really their fault in some ways, their myopic focus. They're supposed to represent everybody, but who do they talk to? They can't talk to the defendants because the defendants have lawyers, and their lawyers are going to say, don't talk to the prosecutor. But who do they hear from? They hear from the victims. They hear from the police officers. So when you have victims and police officers talking in your head all the time, and you never have defense talking in your head, you wind up getting an orientation that is different over time. And so I think having that infusion, whether it's defense attorneys or ACLU lawyers or community leaders, like religious leaders from the community or NAACP people, if you had a group that would go through and make charging decisions together with prosecutors, right, to give them that kind of feedback at that early end, that would both, I think, temper a little bit and provide community input into those decisions. I also think in an ideal world, I don't think this Supreme Court will do it. The United States Supreme Court has really abdicated a lot of responsibility for using the Constitution to regulate plea bargaining. So there are a bunch of cases that talk about where this concept was raised of vindictive prosecutorial behavior in plea bargaining. So let's say prosecutor comes in. Remember that case I mentioned earlier where I said there was an individual who was being loud in public and then pulled the arm away. Suppose a prosecutor had only charged with disorderly conduct, right? And they come in and they say, all right, plead guilty to disorderly conduct. And the defense attorney says, well, he's not going to plead guilty. He's got, he thinks he was exercising his First Amendment rights to talk. He doesn't want to plead guilty. And the prosecutor says, well, if he doesn't plead guilty, I'm going to add on resisting arrest, and I'm going to add on assaulting a police officer, and suddenly he's going to face felony charges in addition. It's that pressure that there were cases that went up to the Supreme Court about whether that pressure should be unconstitutional, and the Supreme Court said no. They said we're not going to use the due process clause in the Constitution to regulate prosecutors that way. I think that was a mistake. I think we should regulate prosecutors that way, but that would take a change at the United States Supreme Court level.
So this is kind of a similar question, but about the sentencing end. So those kind of extreme inconsistencies in sentencing that you were describing for similar offenses, what types of restrictions, regulations, reforms, or alternative approaches do you think could be integrated to kind of reduce those sentencing inconsistencies and make the system fairer for all defendants?
Well, one thing is to not go to prison sentencing at all, right? To think about things in a more restorative justice perspective. This is, I think, part of the abolition movement that Alec Karakatsanis spoke to you guys about. Prison is very ill-suited to actually help anything. And part of the problem, I think, is that our sentencing regime is so focused on prison. And the grids are all about the length of a prison sentence. If you expanded that lens, if you thought about look, what if we sat down and we had a defendant and a person who was harmed by that defendant in a circle with community members, and we had real conversations about the pain that this defendant's action caused people. And you had situations where the punishments are to make the defendant understand, appreciate, and want to change that pattern. So if you ever read Danielle Sered's book, Until We Reckon, if you haven't, I highly recommend it. It's a wonderful book. She talks about an organization she runs called Common Justice, where they sit down in these circles and they think about how to restore society. And it winds up being much more beneficial to both the victim and the defendant in the end than any prison sentence could be. And there are stories in there that will really move you about the power that restorative justice can have, right? Where you have someone who, let's say there was a mugging of some kind, right? Or an assault on the street, and the person, or a carjacking, let's even say, and there's an individual who says, like, I am scared to get in cars now because of what you did to me. So for a month, I want you to not get in a car, and I want you to see how that affects your life. And so the defendant agrees for a month to not get into a car, and they come back together in the circle, and the defendant said, like, I just never realized like what that could do, right? Like, that's been really hard, and like, to the extent that I caused that for you, I'm sorry. And like, sometimes what people want, there are studies about this in medicine too, sometimes people want an apology. Like, our system doesn't really have that as part of it in any real way. And, you know, the pound of flesh of sending somebody into prison, like, it doesn't, there are some victims who think that will make them whole. And if you talk to them later, they will often say to you, I thought I'd feel better. I don't feel better, because like, you can't fix being a victim of a crime just by punishing somebody else. You might need more. And what if there's more that we could give them? So like, how would I reform sentencing? I would think about sentencing really differently. Like, I would think about, what are the problems that got the individual into the system, and how can we stop that cycle? I would think about, what are the ways that we can engage in restorative justice dialogues to heal a community that is torn apart. Because one of the things that people don't think about a lot when they think about sentencing is that it's that revolving door of how the criminal justice system operates on a community. Today's victims are tomorrow's defendants in a lot of these courtrooms, because this is a community that is policed and has a lot of violence in it, right, as a result of that presence. And so like, you're going to have situations where like, these roles are fluid. People don't think of it that way, but they should, because you can do a lot of good for a lot more people if you think of it that way.
So another question, how big of a role do you think forensic science plays in plea bargains or in problems with the criminal justice system more broadly? And do you think only allowing certain types of forensic analysis, or making those forensic labs more independent, separating them from prosecution and law enforcement, do you think that those would help resolve some of the problems that forensic science plays in the criminal justice system?
Yeah, I could have done a whole different presentation about wrongful convictions and their causes, but forensic science flaws is right up there. I mean, the four biggest causes of wrongful convictions are bad eyewitness identification procedures, flawed forensic analyses, official misconduct like prosecutors withholding evidence or government informants that lie because they're jailhouse snitches, and bad lawyers and false confessions. Like, those are the big causes of wrongful convictions. Of the first 330 exonerations that occurred in this country, 71% involved some kind of forensic scientific evidence. There's a lot of places where, and this shouldn't surprise you, like, we have this CSI effect, right, in society. Like, we all think there's science that can quickly identify people and we can figure it out. Your fingerprints, the hair you left behind, the footprints at the crime scene, bite marks. We can all determine who the criminal was if we just do the requisite scientific analyses. And part of the problem is that a lot of these forensic tests that wind up getting used in court, they aren't created by scientists. They're created by police officers, right? They're created by officers who are trying to investigate crime, who come up with something that is loosely based on some kind of scientific principle. And they then think that this will be a way of identifying people. And if you don't have defense lawyers who have the time and resources to actually dig beneath what is the seeming superficial surface that sounds scientific and good, then nobody tests those. And so they wind up being false forensic science. So, I mean, I'll give you an example. This is one of my favorite examples. There's a couple of police officers out in the West who developed something called a drug recognition experts, right? These are police officers who think that when they pull somebody over for driving under the influence, that based on a series of steps, they can not only opine whether you're under the influence, but of what drug. So like they look at your eyes, or they dilated your pupils, or are they not? They feel your muscles, like are they tense or are they flaccid? Right? They like look at the color of your skin. Is it like, are you pale? Are you not? And at the end of this, they say, you're high on opioids, right? Like it's such hocus pocus, right? The funniest thing about it is the last step is do a drug test that will then tell you what's in their system, right? Like that's what's actually doing the work. It's not this opining, but it sounds scientific. They dress it up. There's a 72-hour training session where we'll show police officers how you do this. And it winds up being convincing to juries because science sounds binary. It sounds like, yes, you were there, or no, you aren't. And it's cloaked in this aura of reliability. So yeah, there's a lot of bad forensics. Like the president's task force on forensics, President Obama had a task force, they documented all the problems with forensics. And so did the National Academy of Science. So like, there's just a ton of areas like bite mark, that's junk science, right? A lot of the hair and fiber is junk. Even fingerprints, actually, which many people think is like the gold standard. There's a lot of problems with fingerprint analyses and a lot of situations where they get it wrong. So that's part of the problem, is just that you have this junk science coming in. And if there is theoretically a test for determining whether junk science should be admitted in court. It's called the Daubert test. And the court is supposed to serve as this gatekeeper, but it relies on the defense attorneys to raise the challenges. Right. And again, it's going to go back to that overburdened, under-resourced system. Then on top of it, you have all of these forensic lab scandals where you've got these lab scientists who are beholden to the prosecution, who are overworked and sometimes like stealing stuff from the lab or using the drugs themselves. We saw these scandals come out both in Massachusetts and around the country, where you have these examiners who don't actually have any qualifications, credentials, or are bad actors. So if you were going to reform forensic science, I think you'd perform more of a gatekeeping function on letting it in to court, and maybe have like also standards for independent labs with specific qualifications and screening by science of the legitimacy of the forensics.
Okay, I think that's about all the time we have. So thank you so much for joining us and for all of the insights you provided. And we really appreciate it. And to all of our students, we will see you all in your afternoon labs shortly. Again, thank you so much, Professor Primus. We really appreciate it.
All right.
Thank you.
Bye.
Bye.